David Gray.
I guess I have come to have a better appreciation for the work that you people do. Sitting through a few months and seeing the challenges that you meet. My name's David Gray, 2536 Beechwood Road, Wilmington Township. I concur with all of the other members of cause in the expressions that they have made very strongly. The Wilmington Planning Commission is to be commended for developing a proposed ordinance with extended and well-articulated protections for our citizens. One radically flawed provision, however, will provide a legal basis for energy companies to punish our citizens by placing above-ground industrial activities in close proximity to residences. Stand in someone's front door and look at a compressor station 500 feet away, emitting a plume of vapor. Smell the odor, feel your eyes burn. Expect the same tomorrow and for the years ahead, as long as the wind is blowing in your direction. Expect also the disruption of families up against repeated redrilling on any given pad. This provision is inhumane. Legalizing a close proximity from wellhead or compressor to a person's home will impede the eventual successful adoption of the proposed ordinance. Thank you.
So just so I'm clear, you want larger setbacks?
I want industrial zones. It's a dirty industry with 600 Olympic-sized swimming pools of water, 600 trucks being moved in and out, 200 trucks worth of toxic chemicals, wastewater to deal with, noise, repeated drillings.
But most of your discussion
With-
was about setbacks and
with-
distances.
A very large buffer, meaningful buffer zone. And if our township is inappropriate for drilling, I don't think we have to apologize for that. We are what we are. That's the reality.
But just to be clear, you're advocating that we take our chances with an exclusionary zoning suit. That if we lose, theoretically could take away most of our ability to regulate this.
You do what's right, and if you really lose, that's what happens.
Thank you.
Okay, anybody else here? Do I have it? Okay, Tom, Shoemaker.
Thank you, Mr. Chairman. Madam and gentlemen, I've been a resident of the township for 70 years now. This is the first time I've ever been to a planning commission meeting, although I was at a few at the county level, and it's good to see democracy back in action and to see you earning your paychecks. No, I understand there's no paychecks.
There actually is a
It's a
small,
little bit of humor.
that may show up someday.
Yeah, my question goes to the timing on the wedding barn ordinance. I gathered, I had the feeling that you are all in agreement as to where you stand on the ordinance as it, in its present form, with the exception of the issue of the R2, on which you're deadlocked, and some housekeeping definition questions that the solicitor raised. If that is the case, and considering that you are an advisory group advising to the Board of Supervisors, would you consider taking action on the ordinance and forwarding it to the supervisors, subject to his definitional changes? My concern is one of timing. As you know better than I, if you defer this another month until November, then by the time it comes to the supervisors, it's December. Then in December, they have a legal obligation to refer to the county planning commission for review and recommendation. And so the township supervisors have to sit on it for 30 days. Then they have to schedule a hearing. Then, at the earliest, it might come up in January, but for the fact that January is their organization meeting. So as a practical matter, by deferring action tonight, the earliest the supervisors could give final adoption would be February, 4 months from now. And that leaves a number of property owners up in the air in terms of where the township is going to come down on this issue. So I would just ask if that would be considered, is to refer it to the supervisors, assuming that my sense was correct, that that there is a consensus, and it's obvious you've done a lot of work on this. But if that's the only issue, would it not be possible to move it along in that way? Thank you for consideration.
Thank you.
Can I ask a question?
Certainly.
Do you have a particular interest here beyond democracy in action?
Let me say, without going into details, this is more than just a mere academic question. You get the gist?
To help you out a little, Tom, one of the things I think most of us sitting here, and certainly I have learned, is marination of this process is pretty important. Sometimes when these things marinate, clarity comes with it. And if we act quickly on almost anything, it's usually a mistake.
Well, I don't.
So, I mean, we've been working on gas and oil for like almost 3 years now, so, and it's still not solved. But to answer your question, I respect what you're trying to say to us, but on the other hand, whether it's December or March or April, it's gonna be what it's gonna be. The process has to run its course, and personally, it just seems to me that sometimes that takes time, it's a good thing. And I don't think you're arguing against that.
I don't want to go into
Right.
details of my
Right.
personal situation.
Right.
But let's just say that, as many of you know, I have my property on the market.
Yeah.
And I have to move for health reasons, but it's been on the market for a number of years.
Yep.
And I understand that this ordinance has been with you for several months now.
Yep.
And I'm just saying that considering that it is not, that you are an advisory body, and that the ultimate decision is with the supervisors. And
Believe it or not,
was
this is
just a
light
suggestion.
speed though.
Pardon?
Say, believe it or not, this is light speed.
May I ask a question of the solicitor?
You may ask a solicitor.
I hate to speak with my back to everyone, so I'm gonna.
Oh, I thought you were gonna speak with your back to us.
No.
I say something that, Mr. Schumacher, I apologize for not getting you during the early time. Somehow I didn't see the paper here.
I didn't turn it in the beginning because I wasn't aware.
Oh, all right, that's why.
But thank
I
you.
did.
That's
I
so
didn't-
fine.
I
You
didn't-
blame him before you said that. Can we legally recommend something to the supervisors without having the language in final form, absent the occasional typo, etc.?
If the board so agrees, you can forward it in the form that you have it in. I mean, I've read it, I reviewed it. I gave you my opinion as to what should be included and what should be clarified.
But if it were the sense of this body to say, yep, we like the changes you recommend, but we don't have time now to massage all the wording.
Would we be willing to leave it up to you to do that?
Well, would we be acting legally
Yeah.
if we said, yeah, we agree with these in principle, and now we leave it to the secretary and the solicitor
To finish it?
to finish it and send it on?
I have your legislation, you have my memorandum, nothing short of my comments and your amendment. If you wanted to forward that to the supervisors as your recommendation, I'm comfortable with it. Because that,
I may be dense, but I don't think you're answering my question.
what I'm telling you is, I have no problem with you referring the document in its current form, subject to my comments that I provided to you in writing.
But then the supervisors would have to amend it.
The supervisors would receive it and then make, I don't want to say changes, but for lack of a better word, implement the things that we discussed and forward that to the Lawrence County Planning Commission.
Thank you.
So you wanna do that?
Well, do we wanna hear from the solicitor on oil and gas things?
I have a question for him on oil and gas. Oh, yeah, he's gonna talk about that. Right, we didn't do that yet. Bingo, you're right.
Ready?
Yep.
Okay, a few things. You've worked on oil and gas here in Wilmington Township for a number of years now. I've worked on oil and gas in a number of communities. I've sat through conditional use hearings. I've gone to court on the ordinance challenges. And there's one thing that I don't want anyone to be buffaloed about, for lack of a better term. I've had experts testify at hearings that buildings can be placed around compressor stations through their own testimony. They can put mufflers, they can put soil barriers, they can enclose them within buildings. So going back to the compressor station argument, tonight, is nothing more than a red herring. Secondly, you're giving Hillcorp and Chevron a second bite at the apple concerning the 500-foot setback. Then all of a sudden, mysteriously, 6-8 months later, we get a map that only 1% of the township can be developed under the current ordinance that was prepared by this commission. Third, with regard to the amendments, I think I stood right in this very room when the Planning Commission indicated that there was not any support to include the water testing amendment or the soil testing amendment. And we accepted the decision from the board. That's nothing short that the supervisors can't propose. So the water amendments never hit this room again because it didn't have any support for the testing.
Didn't have majority support.
Thank you. With that, there are some overlaps with some of the information that Mr. Lucas provides. And one of the overlaps that he talks about is mandatory water testing, making it a requirement. And the other thing that he cites with case law is the 2,500 feet is a little large than some of the requirements that have been struck down previously at 1,000 feet. So how got back to the board is that a number of citizens spoke up at the public meeting of the supervisors and said, hey, how are you going to act on the the oil and gas ordinance when the Planning Commission didn't have any time to consider the Robinson case? That's the only reason it came back to you. You can sit here and make a motion tonight that you've looked at it, you've read the memorandum from Mr. Lucas. I provided a memorandum in short order, basically interpreting their arguments. I only received it yesterday, and it was addressed to Wilmington Township. I did receive a copy of it. So in short order, in less than 24 hours, I'm asked to decipher what they put together in short order. So in that regard, if you decide to take action on the oil and gas ordinance tonight, that's fine. If you want to refer it back to the Board of Supervisors, that's fine as well. But the final document has not been prepared and advertised for the public comment hearing portion to adopt the ordinance.
Could you,
And that's where we were at the Board of Supervisors meeting. We were ready to pick dates to have a public hearing, to take public comment, and that's when a few of the residents commented on sending it back to the planning commission.
Okay, I got two questions for you. So given your explanation as to why you sent us the material in the first place, it seems to me that if we acknowledge we received it, and I make a motion, or somebody makes a motion that says that we see no action to be taken on our ordinance per this new ruling from the Supreme Court, that's that.
Yes,
We've looked
sir.
at it, and we've dealt with it, it's in the minutes, and the story.
Yes, sir.
Okay, that's question number one. Question number two, in your discussion here, you note the water, correct? You note the enclosure issue with the, compressor stations, that's correct.
And I have this, not to interrupt you, I have that in a transcript. You're more than
Yeah.
welcome to,
Yeah. No, no.
appear at my office
That's
and read
fine,
it.
I accept that. But the setback issue, pretty clear. We didn't know at the time we put that in place exactly what would be left out of our township in terms of what would be available in terms of land. Fair?
And I think that's a good thing, not a bad thing.
Well, okay, but we put it in, and you're right, they didn't respond, there were grumblings about it, no question, as well as the water and a few other things, it was very clear, but they didn't act on it, okay? You received the same memorandum that we all did, and I've read it, you've read it, maybe.
Sure.
Do you see a legal challenge to us? And I'm thinking specifically on the setback issue, not the other issues. I think that, to me, in my mind, is the strongest of all, that what we've done in effect is precluded any reasonable area for a compressor station.
I disagree with your last statement, because I don't think the board intentionally did anything
No.
but work.
No, but
Work through those
let me
issues.
back up a second. If we were to proceed with the current ordinance as written, and the supervisors had their hearing and they passed it, okay, could that ordinance be challenged per the result that is contained in it, that there's no place to put a compressor station?
The easy answer to that, I think you're gonna get a challenge either way.
Fair enough, thank you. That was the third question I was
You're
gonna
gonna,
ask.
you're
Okay.
gonna get, on,
Okay.
on what you have in place,
Yep,
whether you,
Okay.
let's say you relax the setbacks to 100
yeah,
for Mr. Lucas.
Yeah, yeah.
He wants 200, you relax
Yeah.
it back to 100, you're still gonna get a challenge.
yeah, okay. I understand that, and I fully walked in here this evening with that in the back of my head, that no matter which way we go with this, damned if you do, damned if you don't, it's gonna be a challenge one way or the other. So it's just a matter of who you want to challenge you.
And
Fair
with
enough.
with all rights, you may have a challenge from both sides.
Right, fair enough.
If there are two
Probably.
sides,
Right.
if you've qualified
Okay.
that there are two sides.
All right,
Can I
so,
ask you a question?
Sure.
As our solicitor, and giving us legal advice to the board, what is your recommendation to us?
My recommendation is to send it back to the supervisors, because basically, you're just looking at something in a snapshot. We still have to go and advertise an ordinance and amendments of what the supervisors want to put forward, and we still have to take public comments on that. So what you've recommended, it may not change at all. It may change a great deal.
but there's a high likelihood that what would go through as written would be challenged.
Absolutely.
Thank you.
a couple of things. Assuming the supervisors consider amendments that we've not dealt with, those still have to come back here.
I think, I don't know which meeting it was, and I could be wrong. Those were already discussed here. However,
You're dealing with a specific set
That's
of
right,
names,
but-
I'm asking more generally.
if, let's say your document changes, and when I mean yours, what comes from this commission, let's say that document changes. Without looking back at my procedure, it would probably pass through here one more time just to say you had it. But I'm not sure that we're gonna get to that point.
I don't know what that
I don't know
means,
what you
but.
mean.
Cause you can't, we're not getting off first base at all with anything. You know, we keep putting legislation through, they keep coming back and saying, well, no, that's not good enough, this isn't good enough, we can't do this, we can't do that.
Okay, are we able to do a motion?
I'm not done asking questions. I mean, I guess a motion is in order any time if you wanna take it, or can we all finish the
Did you
question?
let him make the motion after he asked for more questions, or?
That's fine with me.
Okay.
So we get to the
Can I
end of
ask
it.
one real quickly?
Yeah, go ahead, I'm looking.
I have a question, Lou, then, just procedurally, again, what is your recommendation as to stop this ping pong game we're playing?
Really?
You know, excuse me for using the term game, I just meant,
Sorry,
it is becoming, I should have not used the word game, I apologize.
not
This,
politically correct.
this back and forth, I was using jargon, I'm sorry.
I think there's 4 issues before you tonight that has, well, lightly. Number 1, should you scrap everything and go back to industrial? And I think that's been considered for 1.5 years or 2 years, that's not the decision that the board's going to make. The issue about the compressor station, to me, it's a red herring, because their own experts have testified, you can enclose it, you can put up soil mounds, you can do all these types of things. The water, there's a preemption problem there, and I think I would deal with the water issue with the supervisors, because that didn't pass with the majority of this board. So really, the only thing that you have to give due consideration that Hillcorp and Chevron are objecting about would essentially be the setbacks.
Yeah.
And that's it, and they're,
Thank you.
they're at 500, you're at 500, they're at 200. If you wanna stay at 500, that's your prerogative. If you wanna make a motion to change that, that's also your prerogative as well.
Okay, thank you.
But we're in agreement, though, there will probably be a challenge, if the setbacks as currently exist in our document are left in there.
Listen, there'll be a challenge if you lower those setbacks down to 100, as sure as I'm standing here.
And there'll be a challenge if we raise them to 1,500.
That's exactly
So
right.
the question is,
Challenge them.
who do you want challenges? Who do you want to challenge us?
Okay, so I'm looking at the MPC 609C, in the case of an amendment other than that prepared by the planning agency, the governing body shall submit each such amendment to the planning agency at least 30 days prior to the hearing on such proposed amendment. So it seems to me pretty clear,
Yeah,
if there's an amendment that we've not considered,
It'll
if we,
come back.
if we voted it down,
It doesn't come back.
right, it doesn't come back to us, but if they came up with something new,
Right,
we still have to be back here.
right.
Okay.
So that would be 750, 500, 200.
Well,
That would be the water testing.
but again, water testing, we've already
dealt
dealt
with
with unless you come up with something that's substantially different. Although we've gotten different opinions over the years about whether a comma draws it back here or whether it's just something substantive. I would hope we could take the latter. Would the supervisors be better off, in your opinion, if we ask them to ask the township engineer to map out the impact of our setbacks, as opposed to us having to rely on an interested party?
I would see no harm in doing that. I don't know what the cost associated with that would be.
My third question, given all the legal things, given the comments that you've heard, and I'm not asking a public policy question, I'm asking for a legal opinion, has this board failed to do its due diligence? Is it taking some action that on its face, I'm not sure this is the right word, would be malpractice?
I don't think you failed to do your due diligence. I just don't think that the individuals that you hear from agree with the final result.
Right, well, that's why I said, I'm not asking a public
yeah.
policy question.
on either side of the fence.
Right.
My only question that I would pose, and I'm not throwing this back to you, but if 500 feet only frees up 1% for the compressor, well, how much does 450 feet, or 400, or 800? You know, we only get what we adopt, and they take exception with. So, I mean, Blaine, have they looked at,
But that's my
because-
reason for
because here-
asking the question.
because here's the point, Mr. Nykerk. Let's say 400 feet only frees up 1%, or 300 feet or 200 feet only frees up 1%. We're no further ahead with 500 than we are with 200. And no one has been able to answer that question for me. Not meaning this board, but
That's an engineering
But-
question.
But the point is, and it goes
I mean,
back
that's
to
an engineer
what
question.
Fred said, we could get an answer to that by tasking the township
Right.
engineer to run those scenarios. And I think if we're going to
Right.
rely on that, we ought to have our independent information, not be forced to rely on the information from an applicant.
But the other thing is, you know, we don't have the availability of all the mapping that the oil companies do, because they've taken into consideration identifiable streams,
Plus another regs.
identifiable wetlands. They've taken all those things into consideration. So my only point is, whether it's 500 or 200, does that 1% even change?
And given that there'll probably be a legal challenge no matter what, isn't this information we would wanna have eventually at some point anyway?
Well, I mean, I'm asking for.
I know it's the cost is the issue, I understand.
No, but
yeah.
I'm asking for someone to accept my offer. There's only one person in the room that can accept that offer.
What's your offer?
The offer is, what is it at 400 or
Oh,
300 or
gotcha.
200?
I'd like to do it every 50-foot increment or something.
I'm just saying, it may not mean anything.
I would guess that if we had somebody else do it, they're probably gonna have exact same program as this is, and plug in the exact same thing, and probably gonna come out looking exactly the same, except they might print it in green.
Because luckily it is objective, not subjective.
Oh, I don't believe that it's subjective.
It's objective.
I don't believe that.
Why?
Because I think you have to make assumptions.
Drawing 50 feet from a line is an
But
assumption?
it's not
or-
just that.
Okay, what's the assumption?
It's where are you identifying streams? How do the setbacks?
Oh, I'm talking
from
about
that
just
work?
setbacks from property lines.
But that's not all
I
that's on
understand, I'm
there.
just saying the
Right.
starting point.
I'll bet just the setback from property lines still eliminates most of it.
We, you know, I know your debate, we certainly encourage the township that wants to undertake an independent review of that.
Well, I guess, I thought a lot about this coming in this evening in terms of pros and cons, in terms of where it leaves us legally in terms of the challenge, okay? And what I'm gonna say is gonna sound like I'm on their side, my God, I'm on their side, but if we get a challenge from somebody in the community, and we have an ordinance that Hillcorp and Chevron believe are defendable, okay, they will defend it. I don't think the township is gonna have to put up the resources, to defend that ordinance. They will, because it's in their best interest. If we put up an ordinance, basically, that is on the line or on the edge, we will get challenged by them, in which case we have to defend it. Our money, our resources. So personally, as I look at and weigh the pros and cons of this, I would like to have an ordinance that is slightly favorable to them, to the extent that it wouldn't be worth their while to challenge it, and it would be well worth their while to defend it. Because as you said, and I totally agree with it, we're gonna get challenged one way or the other. It's a matter of who does it and who pays for it.
There's a few
Please.
things that I have to fill in the blanks.
Go ahead.
Any challenge is gonna be initiated through, essentially going through a couple steps. A writ of certiorari filed against the township, then we have to produce the record. So there's gonna be expense no matter which
Yeah.
side challenges
No matter
it.
how much.
It's just gonna matter be
Yeah,
who's seated at which table
yeah,
in the courtroom.
yeah. Okay, so can I make a motion?
Sure.
I'd like to move, that we suggest to the township supervisors that they go back to the December 2015 ordinance and simply re-advertise that ordinance with the word hearing as opposed to meeting, and submit that ordinance, to public review, and if they wanna pass it, pass it, or if they don't wanna pass it, don't pass it. That ordinance was already passed, it was already put in place. And if we review from that point in time to how we got to this point in time, it came from a threatened court challenge to the township through our supervisor, or through our solicitor at the time, who sat down with all concerned parties, worked out a list of considerations that were put back on our table that we then had to incorporate into a new ordinance after we passed the old ordinance. And here we are, with additional things being piled on. And we've got this ordinance now into a position where there's a legitimate legal challenge that could come from our oil industry, oil and gas industry. And who's gonna defend that? I, for one, think the best position to be in is in a position that they won't challenge the ordinance, and in fact, will defend it. So my motion is that this committee recommends to the supervisors that they go back to the December 2015 ordinance and re-advertise it and reconsider that ordinance.
That's a question.
It has to be seconded or it's not before us.
We have a motion, we have a motion and a second.
I'll second it, but I have a question. Go.
So again, that's just your opinion. What's your sense on what the supervisors would find most workable?
In
To go back to a stripped down version and then use new information?
you know, not to skirt the issue on your question, you know, there's been very limited discussion at all concerning this. I think each individual supervisor has taken the information that's been provided at the public meetings, processed it, and talked with me, you know, individually about it. We haven't been in a position to sit at the podium to discuss it openly or publicly as to what the desires of the entire board may be.
So what you're saying, you need a public hearing so you can do that?
That would have been the next step, but for this coming back to the planning commission. It would have been the ordinance that came out of this commission with 3 separate amendments for discussion and consideration by the Board of Supervisors. 2 of the amendments dealt with water testing. 1 amendment dealt with soil testing.
If we send back the one Fred mentioned, which does not include those
Nothing in
amendments,
it, right.
then it would have to be sent back to, if they choose to incorporate those into that version, then it would come back to us again at that point, correct? Because the version we sent didn't include those ordinance, or those amendments.
Those amendments,
Okay.
correct.
Okay.
There were 10 amendments, I believe, you're referring to
Yep.
that Mr.
Solomon
Solomon
submitted to the.
drafted
Yep.
and submitted.
Yep, and we sat down and put them all in there, and then more stuff came in, and here we are. We're sitting here with, you know, a whole bunch of stuff that obviously is gonna get a challenge. So, as I said, and I repeat, who do you want the challenges? I know who I want.
Jay?
To speak against the motion, I don't think our concern ought to be who's going to challenge us. I think our concern ought to be what's good public policy.
Wait a minute, what? How much money do you,
I
of the
take
taxpayers' money do you want to
exception
spend to
the
defend that?
responses.
Pardon?
Sorry,
I interrupted you, I'm
no, I
sorry.
was being unhappy. I don't think it's appropriate for the kinds of responses we just got. I understand the question of cost. And if the solicitor tells us we are in a legally indefensible position, that's a different question. But the 2015 ordinance did not contain a number of things that are in this ordinance that even the group you're concerned might sue us seems willing to accept. In fact, it seems to me there's only one issue here, because water testing isn't what's before us. We're not proposing it only be an industrial. The only issue is the question of setbacks. And to throw out everything else we've done over a question of setbacks that may or may not even get any traction strikes me as incredibly unwise. I actually think we've come up with a reasonable balance, and maybe the fact that neither side likes it is an illustration of that. I think it's probably the best balance we can get. I'm perfectly willing, because this is such a big issue, to say, yep, we gotta ask the township engineer to map out the setbacks so we can see if we have some question about reasonableness. But I don't wanna throw out everything else we've done. I don't even know, well, yeah, I don't wanna throw out all the other things we've done that are apparently acceptable that do take some steps toward at least mitigating some of the issues in the community. So, going back to 2015, and again, I don't even know exactly which ordinance that was at this point, because they passed one.
It was the one passed in December. It was put in place. They repealed the old one,
Okay.
put the new one in.
Okay,
So we had a clean ordinance that was done.
Wasn't it labeled ordinance 1 of 2016?
Something like that.
no,
Is that not the one?
no, it's the 2015 ordinance.
On my
Okay.
computer, it's ordinance
But-
that was done in August.
We have a number of things in here that are an improvement over that, and I don't see why we'd wanna throw them out. They're not even being challenged.
Yeah,
Well, if, at a minimum, I would say, if the company was here telling us they wanna be good neighbors, challenges something they haven't raised concerns about, at a minimum, they're not being good neighbors, and I understand that's not a legal argument.
Well, we've already sent something to the supervisors here a few months ago. And that was sent, what was sent when?
I don't remember.
That was sent back in June or July, I think.
We recommended that they approve that. I would be in favor of saying back to the supervisor, instead of going back to the original ordinance, going to the one we sent them in July and saying, adopt it or reject it.
Well, that is what's.
That's what
That's what
That's
we've
the
done,
same.
that's what we did.
That's what we did.
And then they sent it
And they
back.
sent it
to-
back.
Right,
So, I
so send
mean-
it back and tell them,
Yeah,
As a result of the court decision.
Correct.
That's why it came
Right.
back to you.
and we've gotten further input with a sense of the legality of certain parts of that document as it stands right now. And as our solicitor just told us, we're gonna get challenged.
yeah, no matter what we do, we're gonna get.
I know, so I mean,
Mr. Chairman, I have a parliamentary question.
Okay.
I think I'm past where I can raise point of order, but I think I can raise this. Is this essentially a motion to rescind our action of sending up the 2016 version? And if it is, since it came without notice, it would require a 2/3 vote.
They actually have an ordinance right now that, it's just back to us for comments.
But my point is.
yeah, but have we not opened that ordinance up basically for further consideration before this body?
But that's not what we're doing here. We're saying the effect of your motion is to undo our action to send up the 2016 ordinance and tell them we recommend they go back to the 2015 ordinance.
Yeah,
That strikes me as a motion to rescind without prior notice. And under Roberts, that
So
has to be handled in a particular way.
okay, it's a recommendation. They can do what they want.
If it doesn't get a 2/3 vote, I don't believe it's a legal motion.
So what's the
Solicitors-
2/3 vote, 3 out of 5?
It would actually have to be 4 out of 5. The solicitor's here, he can tell me if I'm wrong under the law, but as I understand Roberts, that's a pretty crucial safeguard.
I haven't heard a second yet on the motion.
Yeah, it was second.
Was it? Okay.
Do you have a problem with the ordinance that we sent them back in July? If we just say, go back.
Well, I think we've gotten further clarification on the ordinance as it exists. I mean, pretty clear, it did come late, I will agree, and it was tardy, all the rest of it, per your comments, they had the chance to respond to us, but nonetheless, they've responded. And we've got loud and clear, a map, and a comment on the water, and a comment on the compressor stations. So, there's one of these that's really gonna be an issue, and that's the setbacks. I don't know that we get particularly challenged on the, well, I don't even know if they're gonna put the water in there, what do I know? It's not in there, it's just a side, it's along with it, so it's not part of it. But the compressor station part is in there, and the setbacks are in there. And it's gonna lead to legality, it's gonna lead to an issue.
No matter what.
No matter what, but my question is, consider this, who pays for it?
And so
Do we wanna put taxpayers of this community in a position to have to defend something, against really deep pockets? Or do we wanna put our taxpayers in a position to defend something with the help of those deep pockets that is a defensible ordinance against whoever in the community or wherever it comes from?
But bottom line, you're telling me that in your judgment, the 2016 Robinson Township decision puts us in worse shape?
No,
Then
I have
we
no
were
opinion on
before.
that. I have no, I read that, I see nothing in it that affects our ordinance whatsoever, to be honest with you. It's just more of the same, it's clarification, it's not, I didn't see any material in there.
Practically, it appears that the supervisors, like us, are going to be most hung up on setbacks. So to me, it seems the best idea to somehow find a way to determine what each 50-foot increment of setback would result in a map. And I don't know the cost, obviously, I don't know how quickly that would happen, but to me, that seems like something, the whole goal is to eventually get something adopted, or something, you know, onto and off the supervisor's table at some point. And to me, it seems like that, from what I'm hearing, that would be something I think the supervisors could make this move forward faster if they had that information. Does that sound correct, Lou?
Let them do it.
I mean, can we make a recommendation to them?
Go back to 2015, and then they got a clean slate, they can add on whatever they want.
No, I mean, I just think they like to have maps.
Yeah, but I think you can only recommend the legislation that comes out of your commission, so to speak. In my logical terms, we've addressed every issue that they brought up. The only issue that I think you're uncomfortable with are the setbacks. So if you wanna keep the setbacks the same, then you forwarded that back to the supervisors. If you wanna reduce the setbacks, you can make a recommendation to reduce it. If you don't feel you have enough information to reduce it, then you forward that to the Board of Supervisors, and we can deal with it when it gets there. And listen, there's gonna be another set of hearings, and I can, not in front of you, in front of the Board of Supervisors. The same individuals are gonna make the same statements on the record. Mr. Lucas will be back, he'll make his same statements on the record, and it'll be up to the Board of Supervisors as to how they wanna move forward. And I've read, from January till now, I've read everything that everybody has presented to the board for review. I mean, it's not like I take it and throw it in a folder. Everything that they've submitted, I've taken a look at, and I'm comfortable with what I see. Your decision tonight, do you wanna do anything with the setbacks or not? That's what it comes down to.
Okay, any more comments about the, motion?
Can I just ask a clarification, what are the setbacks in the 15 one?
200, I think 200.
200?
I'll have to look.
This one.
You got it there?
I have 5 minutes.
In 2016 or 500?
Yeah,
Well, for what?
Compressed.
compressor station to a property line. And the old one had from a compressor station to a building.
Correct. Which meant, just so we're all clear, that if your building wasn't right at your property line, they could build this right next to the property line.
Compressor central station, property line 200 feet, public road 100 feet, building 750 feet, public water intake 1,000 feet, intermittent stream 0, perennial stream 300 feet, wetlands 300 feet, and then floodplains covered by perennial streams. Anyway, so it's 200 feet to a property line, 750 feet to a building. And we went to 500 feet on a property line, and I think we left the 750 on the building.
Right, that's the 2016. Thank you.
Which one's in effect right now, the 2015?
Correct,
2015
is
is
operative.
in effect now, but is
That's
under
running
court
with the
check.
but under a challenge, because we use the word meeting instead of hearing.
And the 2016 one is what we have most recently recommended to the supervisors to replace.
Okay, well, at any rate,
But the
we had-
supervisors approved the 15 version.
Correct.
Correct.
They did approve the 15 version.
That's
Based
why-
on that procedural,
Well,
it was challenged based on that one.
but also under legal advice from the solicitor, that is not what we're getting anymore.
What's that?
That one was approved partly under legal advice that that's as far as we could go.
Yeah, and then we got, after the fact, we got 10 more issues that we were supposed to consider. And then we did. And then we got additional issues that came after that. And here we are.